Today, I am presenting legal aid program across the country. First of all, I would like to discuss the historical background as to how the legal aid concept came in India. But prior to that one, the earliest legal aid movement appeared way back in the year 1851 in France. Later on, it came to Britain, and that was in the year 1944. The main purpose for this legal aid service was to help the indigent, the poor, especially the marginalized section of society. And it was in the year 1952, the government of India started addressing to the question of legal aid for the poor and the marginalized section. And it was not until 1980, a committee of the national level, which was constituted under the chairmanship of Honorable Mr. Justice P.N. Bhagwati, took over the mantle of helping the poor, the marginalized section of society. And this was to extend the legal services and the legal aid. And this committee came to be known as the Committee for Implementing Legal Aid Schemes. And it started monitoring the legal aid activities, which was extended to the marginalized section throughout the country. And this did not have the statutory backup. And it was not until 1987 the Legal Services Authorities Act came into existence. And through this act, the legal base was formed for the legal services to be extended across the length and breadth of the country. And this act was finally enforced on 9th of November 1995. And that time, Honorable Justice R.N. Mishra played a pivotal role in the enforcement of this act. And in the year 1995, on 5th of December, Dr. Justice A.S. Anand was instrumental in establishing the National Legal Services Authority. And he took over as Executive Chairman of National Legal Services Authority in the year 1997. The National Legal Service Authority was established and formed in the year 1995, but the operation and the functional part of it was initiated by none other than Honorable Dr. Justice A.S. Anand, who took over as the Executive Chairman of National Legal Services. And he initiated most of the services and made the National Legal Services Authority functional one and operational one. And we have to see the origin of this legal aid in our constitutional provision. Article 39A, yes, talks about providing free legal aid to the poor and the weaker section of society, the marginalized section of society. And Articles 14 and 22, Clause 1 of the Constitution also make it mandatory and obligatory to the state to ensure equality before law and equal protection before law, and a legal system that should promote justice, that is on the basis of equal opportunity to all. So it is not only in the constitutional provision that we find the concept of legal aid, but we also find the mention in the Civil Procedure Code 1908. And here the Order 33 and 44 do talk about providing help to the marginalized section of society, to the weaker section. These are the provisions of law, one in the constitutional law, the other one in the statutory act, that is the CPC 1908. Do find actually the mention of legal services authorities as well as legal service to the poor, to the marginalized section of society. And as I told you earlier, yes, in the year 1987, the Legal Services Authorities Act was enacted. And it came into force actually in the year 1995 with the establishment of the National Legal Services Authorities. And Section 21C of the Legal Services Authorities Act 1987 includes rendering of services in the conduct of any case or other legal proceeding before any court for which the help is extended to those who cannot afford the services of a lawyer or those who cannot afford the legal services. And it is to provide the competent legal services to the weaker section in society. And that is to provide equal opportunity so that the marginalized section should not be deprived of this legal service. And in every state, because the legal services authorities are working and functioning at different level. In every state, you find legal services authority constituted, of course, under the directions of NALSA to provide legal services to the poor, to the indigent, and also to conduct the lok adalats. Now, state legal services authority is headed by the Chief Justice. They are at the central level for NALSA, who happens to be the patron-in-chief, the Chief Justice of India, and then the Executive Chairman, Present Honorable Justice UU Lalit, is heading now the National Legal Service Authorities. And state level service authorities is headed by the Chief Justice, and then State Legal Services Authority also would be having a retired judge of the High Court who is nominated as Executive Chairman. And at district level also you have the Legal Services Authority constituted at every district to implement legal aid programs and the schemes at the district level, which would be taken care of by the district judge who happens to be the ex officio chairman. Then at taluk level, the legal services authorities are working with the help of the legal service committees, which are constituted at the taluk level, mandal or group of taluk, in order to coordinate the activities of legal services. And here, this particular taluk legal service authority is headed by a senior civil judge operating within the jurisdiction of the committee, who happens to be the ex officio chairperson. Now, we need to know about the objectives and mission of the legal services authorities. Basically, the provisions which have been shown do reflect that the country, the government, serious about extending the legal service support to those who cannot afford. The marginalized section of society is to be helped on equal footing with those who can afford, providing them the best and the competent legal service that is available. That is to legally empower the marginalized section of society, helping them in representation, extending the legal literacy programs, legal literacy awareness, and bridging the gap between the legally available benefits and the entitled beneficiaries. Now here, the government may be floating certain schemes, certain programs for the benefit of the masses. And these programs ought to be brought to the notice of the common man. They need to know about the programs and the schemes and the policies floated across the country by the government in the interest of the citizens, for the benefit of the citizens under the welfare schemes. Now here the legal service authorities do act as a facilitator in providing the benefits of these programs. That's how the bridging the gap between the legally available benefits and the entitled beneficiaries. So those who are entitled need to get the benefits out of the government programs under the welfare schemes floated by the government across the country. And the other objective is to strengthen the system of Lok Adalat. It is to settle the disputes through negotiation, mediation, conciliation. And this platform is not an expensive one, and it is accessible to all. The concept of Lok Adalat, that is the alternate dispute resolution mechanism, is to provide resolution to the disputes in a quick and inexpensive manner. And that to be the resolution would be a very effective one. And of course, this is done actually to minimize the load of adjudication on the overburdened judiciary. The judiciary is overburdened with not many cases. Now, the concept of Lok Adalat is to ease off the burden of the regular courts. And we also know very well that justice, that is social, economic, and political, is enshrined in the preamble of our Constitution. And keeping this in view, the incorporation of Article 39A under 42nd Amendment of, that is 42nd Amendment Act 1976, was incorporated for the main purpose of providing justice to the common man, justice to the marginalized section of society, justice to the weaker section in the fields of social, economic, and political. And this is the very purpose for which the legal service to those who cannot afford is provided. And legal services can be availed from different channels. The first one to begin with is the Supreme Court on top. The Supreme Court Legal Services Committee 109, Lawyers Chambers, Supreme Court of India, New Delhi for Supreme Court cases. And State Legal Services Authority, that is High Court Legal Services Committee, situated at every High Court complex for High Court cases. And District Legal Services Authority, situated at the District Courts complex in every district. Now, legal services authorities, they are functioning at different levels. And at the centralized level, we have seen NALSA and how it is coordinating with the various legal services authorities at different levels, at state level, district level, taluka level. So hats off to the National Legal Services Authority for coordinating these bodies and making them function towards the goals and objectives for which the legal aid program has been instituted, has been incorporated. The functioning of NALSA is basically, and the other legal services authorities put together, would be providing free and competent legal services to the eligible persons. The eligible persons have been defined under Section 12 of the Legal Services Act 1987. And they also organize Lok Adalats for negotiated settlement, amicable settlement of disputes, and organize legal awareness camps in the rural areas. And this legal awareness is the most important component of this legal aid services, because the information is to be disseminated across the country, the length and breadth. The awareness has to reach the masses to the grassroots level, to every village, to every rural area inhabited by the people who might be unaware of most of the programs floated across the country by the government under the welfare schemes. So it's not only awareness about their rights, but also about the welfare programs, and also about the various policies, guidelines initiated by the different legal services authorities. NALSA also undertakes necessary steps by way of social action litigation with regards to any matter of special concern. And as I was telling you, yes, it facilitates in helping out the people to attain and to achieve the various benefits provided by the government. And that, of course, happens to be the objective and mission of the legal services authorities. That is, the poor, the marginalized section should receive the benefits floated for them. If they are left deprived of these benefits floated under the welfare schemes, then the very purpose for which the legal services authorities have been constituted would be lost. So religiously, these functions are followed across the length and breadth of the country to cover up all the rural areas, reaching out to the largest number of villages. We shall be coming to the contribution that the legal services authorities at different levels have made across the length and breadth of the country. And this particular concept of lok adalats, for which amicable settlement of disputes, especially the cases may be in the pre-litigation stage or post-litigation stage, the cases may be dealt with, and the services may be provided to deal with this pre-litigating cases and post-litigating cases, or pre-litigation and post-litigation, as the case may be. So free legal services, aid provided by the legal services authority, and these services, as we know very well, have been enshrined, have been included, have been incorporated under the Legal Services Authorities Act 1987, and of course headed by the National Legal Service Authority, as I told you earlier, and who are entitled, if you happen to see under the purview of section 12, these are the people who are entitled to free legal services: a member of a scheduled caste or a scheduled tribe, a victim of trafficking in human beings or beggar, as referred to in Article 23 of the Constitution, a woman or a child, a mentally ill or otherwise disabled person, because the purpose was to serve the community, the marginalized section, the poor section, the weaker section, in providing them the legal services for their representation in respective cases in the courts of law. And those who are in custody, an industrial workman, a person in receipt of annual income less than 1 lakh rupees, depending upon that is state to state, the figure may differ. So these are the people who are entitled to free legal services under the purview or the parameters of section 12 of the Legal Services Act 1987. A woman, a child, and a senior citizen, yes, these are the parties who are entitled to receive the benefits of these legal aid programs. And a child is eligible for free legal aid till the age of majority. A woman, irrespective of her status, is entitled to receive and is eligible to apply for free legal aid by virtue of a section, that is 12C of the Legal Aid Services Act 1987. And any individual, for that matter, above the age of 60 can apply. Then provision of free legal aid includes. Thank you.